it's hard to pretend there's any great consistency in the Constitution and its interpretation by the court. But I think that clearly I think we've got 4 votes there. The question is, do we have a 5th? I mean, there's no question Clarence Thomas is very pro-Second Amendment. Alito has published a book in which he mentions the Second Amendment very favorably. And I think Roberts, from his confirmation testimony, seems favorable to the Second Amendment, and there's some word that Alito is. So that I count as 4. Do we have a 5th? I don't know. But, the Second Amendment is something that crosses a great many divides, where you can have persons who are very much on the liberal left or the conservative right, and both forms of the conservative right, the libertarian right and the rules right, as I call them, all supporting the Second Amendment.
In the small print of the Parker decision, they made it quite clear, that it's an individual right, but government has a right to control and regulate firearms. Am I correct about that?
Yeah.
Now, we take this to the Supreme Court, and suppose they agree with the Parker decision. Sure, you have a right, but government can control it. And I can just see governments throughout America, especially in California or New York, Chicago, D.C., saying, well, sure, you've got a right, but here's some reasonable controls on it. And when they get done being reasonable, they'll have turned a right into a mere privilege.
Well,
and I wonder if people are really thinking about this. Maybe I'm the odd duck here.
No. Any Supreme Court ruling is just going to be the start of the fight. I mean, if you get this is an individual right, okay, now we start the legal battle. If you look at the battle for civil rights in the courts, I mean, that starts at the highest levels in the 1950s, gets off to a very slow start, several decisions. You finally build up to Brown versus School Board in the early 60s. Then you have a whole set of battles in the circuit courts throughout the late 60s, early 70s. Same with the Warren Court change around in rights of criminal suspects. That was a process that took about 10 or 15 years to evolve. It would be the same here. You start out with the Supreme Court ruling, and then you get down to the actual fighting over what in the heck does this mean. It'll be 10 or 20 years easily in that process. And yes, there will be arguments. This is reasonable. That is reasonable. And those will be fought out one at a time. And probably for the first 5 years of it, the Supreme Court won't touch it. It'll let everybody else fight it out so it doesn't have to stick its neck out. Then it would take a case or two and say, no, that's not okay. Yes, this is okay. I mean, what we're really looking for would be something like the treatment of First Amendment rights, freedom of speech, where, yes, you can put some regulations on it. However, they are very few and far between. They are highly suspect. You better have an extremely good reason why you needed it, and it better be as narrow as you possibly could use in order to meet that need. So, we could come up with something like that. Or we could come up with what we've seen in a number of areas like economic activity, where reasonable regulation amounts to whatever the legislature dang well pleases. But, that's the battle. If we win in the Supreme Court in Parker, that'd be the battle of the next 10, 15, 20 years.
Okay, well, and it's good that gun owners understand 15 or 20 years before nirvana comes upon us.
Yes.
So, even after that, I suppose they could still say that you can, or the government can still have some form of regulation for firearms. We'll have to wait 15 or 20 years to see what happens there. Okay, well, how long do these folks have to approach the court, and then when do you think the court would likely decide whether to take the case?
They have 90 days to file a petition for certiorari, which is the technical way you take an appeal to the Supreme Court in this setting. So you have 90 days to file the petition. I forget exactly when Parker came down, but I guess we've got about another 60 days. So That'd probably put them into June or July. And you need all that time, by the way, since any filings with the Supreme Court have to be printed, at a printing establishment, and have to be absolutely perfect, no typos allowed, that sort of thing. So it takes all that time. But let's say they have to file in June or July, by then the Supreme Court will be out of session. They take a summer break up until the first Monday in October. So they'll file in June or July. If there's opposition, it'll be filed over the summer, and then finally the Supreme Court will come back in the first Monday in October, and we'll probably hear about it shortly thereafter.
Okay, suppose the Supreme Court decides not to take the case. Where do we go from there?
Start picking out federal gun laws that are particularly oppressive and file a challenge to them in D.C.
What particular federal gun control laws do you think are quite oppressive?
We'd have to find the most extreme cases. Maybe the domestic violence restraining order. Take another shot at that, although Emerson did uphold it. Things like that. You're looking for as close as you can come to something that absolutely bans a gun or a gun type and applies preferably to a broad swath of people.
Well, what about the ban on the new manufacture of machine guns?
You wouldn't want that to be the first challenge. You're looking at getting a toehold and gradually expanding it. If I was on the court and you challenged the new manufacture of machine guns, you'd get my vote. But I'm not like most judges. There might be a tendency to go up there, well, we are talking about machine guns. Surely that's a reasonable regulation. You're looking for some corner where you can get another ruling that, there's no way in heck this can be classed as reasonable.
Okay. This is Talking to America. Our guest today is David T. Hardy, author and scholar. David has produced many books and films, including his latest, In Search of the Second Amendment. And I'm your host, Aaron Zellman. David, all that we've talked about now, what is your best guess as to who would win, and if they do?
I'd say, I think we win. The pro-gun side wins. I can't tell you exactly who, and it's by no means a sure thing, but I think we've got 4 votes in our favor, and all we have to do is pick up one more to get 5 votes, so majority. And I think there's a 5th vote out there somewhere. So I think we win.
Who would you speculate is the 5th vote?
Kennedy's the traditional swing. I can't tell you, that he's pro-Second Amendment. I've been doing some looking into the court, and I can't find any specific indications as to how he thinks. Curiously enough, Ruth Bader Ginsburg of the liberal wing has had at least one ruling where she mentions Second Amendment favorably in passing. And I forget exactly what it was, but it was just something that brought it in with other individual rights. That could just be coincidence.
Was this there was a decision dealing with the interpretation of the people?
Yeah, I believe
it was. Could that have been it?
That could have been.
Okay.
Yeah. That could just be coincidental drafting and doesn't reflect her real feelings, or it might reflect her real choice.